Lawsuits coming hot, Nintendo's on the prowl. You thought they wouldn't notice, they're lawyered up right now. Cativa, Foxgull, Pangolin 2, looks like Pikachu just filed lawsuit. Grizzbolt, Jolthog, Spark its glare. Is that Luxray or litigation in the air? Gotta sue them all, gotta sue them all.
For China!
Yesterday, we got an update on the Pokemon patent that could quite possibly permanently alter the gaming landscape in a negative way. Well, of course, unless you're a Pokemon fanboy, then you probably think it's the greatest thing you ever heard in your life. Everyone that's not Pokemon gets shut down and only Pokemon exist. Woohoo! Of course, that's the worst outcome. For those of you who didn't get a chance to watch that video, I'll leave a link to it down below. But trust me, you're gonna wanna watch today's video just as much, because the patent that Pokemon was approved of in the United States was for the summoning of other characters to fight for you on screen, which, as you know, is far too broad and could affect many games that are not Pokemon-like. For this very reason, I got a chance to bring on Florian Muller, and we had a lengthy 2-hour-long call, which I have condensed the best parts into this video for you as we walk down how such an extreme patent was even approved of in the United States. And when it comes to Florian Muller, you will not find another guy who is more invested and dedicated when it comes to patent laws and copyright. He gladly broke down every little detail of this for you, the viewer, and for me. I will leave links down below to how you can contribute or follow him, as he is literally an expert on this. I felt so out of my element. Usually when it comes to things like this, I just give you my own personal take. I often don't get a chance to bring on professionals, but I was honored that he gave me even an hour of his time in order to discuss this, as it is something we should all be taking serious. As he said himself, this is an era where gaming companies are aggressively litigious with how big corporations have become. They now have the legal and financial power to hinder competition. I was only able to give you a summary of this new patent, but thanks to Florian Muller here, we're able to understand why the language is so ambiguous and seems to encompass way more video games than just Pokemon. Before we press play on that, just want to remind you, thank you so much for the incredible amount of support this channel gets. Still, continuously over 1 million views a month. Last video you guys gave me over 400 subs. If we can break that number again so we can get to 110k subs so I can play La Cucaracha on guitar, that would be amazing. With that being said, take it away, Florian. The man himself, Florian Muller. I've been watching, or should I say reading your stuff closely since the ABK merger back 3 years ago, and I gotta say, I really enjoyed your coverage of that.
Yeah, well, first, thanks for the invitation, Fritanga. Nice to meet you too, and particularly now to have this opportunity to discuss this topic for your audience to understand and maybe explain some of these things beyond just what I've written. So 2010, I started following patent litigation and covering it in detail. So I've personally attended hundreds of patent hearings and trials at different courts in the US, in fact, as well. San Diego, San Jose, for example. I've followed a lot of things via live streams when they were available, especially during COVID. And I've gone to a lot of courthouses in Europe. So I had the opportunity to build some experience over these by now more than 15 years of following patent litigation, and you then get a feel for what does a party, for example, a patent holder want, what does a defendant to those claims want, and also how likely are the courts or the patent offices going to lean one way or the other. And that's what I've been doing now for quite some time. And about 2 years ago, I started 3 websites: IPFray, GamesFray, and AIFray.
I can say that what you're doing absolutely is good for the gaming community, because, you know, a moron like me would not be able to understand these things if someone like you wasn't deciphering it for me, to be real with you. I get the most basic, the most basic patents, like when they're narrowed down, they almost seem too ambiguous or too broad, And that's where like someone like you really comes in and helps a lot, because the patent we have here is 20, like it's like 45 pages, but yeah, I mean, we're probably not going to be looking through all 45, obviously, but I figured once you looked at it, you could give us a pretty good answer as to whether or not this will actually, serve Nintendo in the long run, or whether or not it'll be shut down, because it was passed in the US, so that drew a lot of concern.
Yes. I think it should not have been granted. I think the patent office made a huge mistake. Let's maybe go back to page 1, if that's possible, to just explain that. Yeah. Page 1 is of limited significance usually. So,
really?
Of course, the number is important. You see the names of these inventors. You see that there's this one Japanese inventor, obviously a Nintendo Pokemon company employee. The title really means nothing. Storage medium, that's up in the top left corner with 54 in parentheses before it, in all caps, exactly. Storage medium, information processing system, information processing apparatus, and game processing method. That could be anything. That could be an AI system. It could be a the controller of a self-driving car. It could be a word processor, could be a web browser, could be anything. That is not something over which Nintendo can sue anyone. So they do not now, because they own a patent on a storage medium, etc., does not mean they own all of them. Then in the lower right-hand corner, basically in the middle, vertically in the middle, but the right column, you have this abstract, which is like a summary of the patent. I normally don't pay attention to them. In this case, the abstract is informative, but there's also patents where the abstract says something that's pretty far away from what the patent is really about.
Okay.
In this case,
what is that?
Because the patent office did not really raise any issues, and because everything went pretty smoothly for Nintendo, that may be part of the reason why there's really no surprise there. So if we could go to page 43, claims. Imagine each claim as being a patent from a legal point of view. So claim 1, claim 9, they are related, but you cannot sue someone just over the patent as a whole. You have to specifically say, these are the claims you infringe. And normally, claim 1 is the one should also read first. That is typically the starting point, and it tends to be the broadest one of them, or one of the broadest ones. Mm-hmm. So after what is claimed it says 1, claim number 1. A non-transitory computer-readable storage medium having stored data in a game program. Why would it say this? This is also, of course, very similar to the title. Well, if they just said, we want to patent the game rule, then it would be rejected right away. So what they have to do is they have to kind of obfuscate this. They have to play this obfuscation game to make it look like a technical invention, as if they had invented not necessarily the wheel, because that's a little bit old, but if they had invented a new type of smartphone or something. So that's why they use this language, non-transitory, just meaning it's not RAM, but it is something that when you turn off the device is still going to be there. Computer readable storage medium. So that's basically just boilerplate. That is irrelevant, because that is, for example, if they were going to sue someone over this, now I don't want to name any particular game because there's plenty of games that have this cast the character and let it fight type of feature, but if they want to sue company A, then they will really have to satisfy all the claim limitations. They have to show that everything that you find here between 1 and 2, so everything that's part of claim 1, and that continues then in the upper part of the other column. That's a little bit inconvenient now for our purposes. So in order for this claim to be infringed, or any of these other claims, you must then prove that the accused product, for example, the accused game, that's what it would typically be here, infringes each and every element. So there's not going to be an argument over the non-transitory computer readable storage medium, because if you run a game and if there's some kind of a video game console or a PC, then obviously the first few words are meaningless because everyone does that.
Yeah. So it's what you're mentioning right here. Lots of games do this right here. So in order for this patent to actually even work for Nintendo, in order for them to seek any sort of legal action, every one of them has to be infringed, or just one of them?
One claim is enough.
One claim is enough. Wow.
Of each asserted claim, they must show that each element of the claim, meaning everything from the beginning of the claim to the end of it, is infringed.
Interesting. And do you think that they are being as specific as possible in order to continue their legal action against Palworld? Because to me, it's very specific, the patents they chose within like the last 2 to 3 years. As you know, a lot of these they didn't seek until around 2022, 2023. Now, I didn't know much about Palworld at that time, but after the success of it, they really narrowed down these patents to 3 specific ones that they were going after them for. But this one right here is a big concern to a lot of people because it involves summoning characters to battle, right? And
yes, exactly. And we're going to get to that now as we discuss these different claim elements. This one they filed for on March 1st, 2023. So that was obviously before anybody could anticipate, including probably the Pocket Pair people themselves, what a huge success Palworld was going to be. So this is one that these types of companies are collectors. They just want to have an arsenal of such patents because they never know whether there may be a competitor against which they want to use them. Mm-hmm. So that's why they try to get what they can get.
Exactly. So, yeah, that's the precedent this is setting, is that Nintendo and the Pokemon Company want to make it seem like they almost own this specific type of system.
Sure. None of the drawings in and of itself gives Nintendo a monopoly over a particular feature. The court will do this. The court is told, we think they infringe claims 1, 8, and 13 or whatever. Mm-hmm. Then the court wants to see a so-called claim chart, where on the left they have the text of each of these claims, and on the right they explain with screenshots and in a textual form how the accused game, in this case we're talking about an accused game, implements each and every one of these things. So it's like ticking off these different boxes in a way. You have on the left you have this, on the right you then explain. Now that's what you present. Okay. Then there could be a debate over what some of these terms mean. If we go back to claim 1, or you still have it on your screen.
Yeah.
If you look to where it says performing control of moving a player character on a field in a virtual space. Talking about what does field mean? Does this mean that it has to be like a green field, that there has to be some virtual grass? Or is it field in an abstract sense? You know, anything where you can move and sit and stand or lie or whatever. It is obviously not a green field that is meant here. It's not about grass. It is clearly basically the playing field. But you could have a debate in court over what field means in this context for this particular patent, not what it means in the to the outside world, but what it means for the purpose of this patent. What is a field? Does it have to be 3-dimensional? Would a 2-dimensional field like a chessboard also be a field for the purposes of this patent? You could have all sorts of arguments just over the term field.
Yeah, because it's interesting because it says a player character on a field in a virtual space. So field and then virtual, and then it follows up with virtual space. So that does, you're right. I get how that could be like open to debate right there.
So but how does the court resolve this? Now the first thing, the starting point is, what is the literal meaning? What would every one of these words mean from a dictionary and common sense point of view? That's the starting point. And then the court will have to resolve any disputes between Nintendo and whomever they might sue over this, over what these things mean. Now, somebody who gets sued is not going to argue over each and every word. He's not going to say, I want to argue perform, I want to argue control, I want to argue to move. But they will pick some that they think could be what's called outcome determinative, meaning they could make a difference. They could make the difference between winning and losing. So the claims are the starting point. The claims, like I said, the name of the game is the claim. The claim continues to be the single most important part here, but the claim must be given meaning. They will look beyond the patent specification if necessary. They will look at dictionary definition. But then they have to look at what is the so-called priority date, the date when this invention was claimed to have been made. Because from that date on, the patent will be in force and effect for up to 20 years if Nintendo keeps paying its renewal fees, which it probably will, because it has enough money to do that and probably wants to keep this patent alive until the bitter end.
Well, why do you think personally that this went so smoothly in the United States?
My theory is that the patent examiners who worked on this, we don't want to, blame them now personally. Nintendo just essentially argued this is a groundbreaking invention. They didn't even provide a long list of similar things, which they could and in my opinion should have. They just made it sound like they had, they had invented a new type of nuclear reactors.
But it's cartoonish to us, but it serves a purpose in this world of patent laws, I'm guessing. So
and obviously they get away with this. Why do they get away with this? Part of the problem is that there are some companies in the games industry that are, as we can see now with Nintendo and Sony, but you now see Nintendo suing Pocket Pair over Palworld. You see Sony with this Tencent dispute that they started in California. But those are outliers. Most game companies, most of these game makers are peaceful, and maybe a little bit too peaceful, because I think other games companies should actually be monitoring what their major competitors like Sony and Nintendo are doing. And they should, in my view, then also challenge these patents. And also when they see an application like this, which is absurd, they should actually reach out to the patent office and submit what's called prior art. Prior art meaning it's something that was publicly available, was published before this, what I call it, the priority date, the relevant date for when the invention was made. If you go to page 25 of the PDF.
Okay, page 25. Gotcha.
Yes. So first it says cross-reference to related applications. So they first filed it in Japan, August 16, 2022. Mm-hmm. And that is, by the way, the reason why about 18 months later it was also published in the US, because for 18 months those applications are in stealth mode. But in February 2024, it was then published, the application. And that, in my opinion, is when others in the industry should just have said, we're not going to let Nintendo get away with this.
And they didn't. It went unchallenged. It went unchallenged. Yeah.
But in other industries, they would do this. I can tell you, if you did that kind of thing, the equivalent of this thing, in a field right now, like, for example, a generative AI large language model technologies or something. If you did this about Wi-Fi or video standards or 5G telecommunication, you would face some resistance if you did something as outrageous as this. But that's because the companies there have a different mentality. And my fear is, even though it would mean that I have more stuff to write about and I get a lot of traffic to my websites, but I have to still separate that from what is objectively in the interest of the games industry and of the gamer community. And it is not for this to become a sue fest. And the problem is that the games industry is now becoming more litigious with respect to intellectual property because of Nintendo versus Pocket Pair, Sony versus Tencent. I'm not saying that these kinds of companies never sued each other. There have been disputes over patents and copyrights in the games industry over these decades. But what we see now is like a new quality of this. There is a certain trend. There is a level of aggressiveness. And if that then triggers some defensive measures by others and counteroffenses, then that's not going to be fun. But so again, I think the rest of the industry has no one to blame for this but themselves, even though the patent office should have done a way better job. But it's also the industry that did nothing about it. They just allowed Nintendo to go forward with this. So what does this mean for the patent examiner? Imagine you're an examiner, you're a public servant, you're under pressure to decide on a lot of patent applications. If you decide, that means you reject or you grant. And if you reject, it may mean you reject many, many times, because after each rejection, they're going to keep trying. At some point, you can then say, this is really the end, or they will just go and appeal. But it's a lot more work to reject than to grant. That's the first thing. The second thing is, so even though the gatekeeper role is really the important one, so then you have this limitation, you have only a limited amount of time. But if there's no resistance from the rest of the industry, then contacting you, submitting prior art to you, and saying, please, we see this Nintendo application. Here we have some YouTube videos of games that already did this 30 years ago or whatever. If you don't do that, then the patent office has to do that work alone with a limited time budget.
That seems to make sense, because it seems more like a preventative measure. Like, this is a patent that, I mean, excuse me for using this language, but they're going to swing their dick around with like smaller developers, smaller companies with things like this, but not really ever challenge someone like Sega or someone like Square Enix.
Right. Sony, Microsoft, those companies have enough patents of their own to defend themselves, and that would not end well for Nintendo. But yes, they can try to assert them against the little guys. I hope that we've actually now spent enough time that they will let you download the next document. But if you scroll down a little bit in the prosecution record on that webpage, this is a summary of the searches they ran. So they use a patent application and granted patent database, and then they run searches. So where the search queries have these things like A63F, etc., those are category-based searches. Then they just looked at, okay, what results do we get? Then you can scroll down a little bit further, and then you see that they were looking for other patents. You see these patent numbers there in some of this, such as AP, US, or US. So they ran searches for patent documents that reference some of these other patent documents. So essentially, the whole search was patent-centric. They just used the patent database. That was it. They didn't even Google. They didn't.
What? that seems ridiculous to me, though, because it's like
it really is, and that's why we get this absurd result now.
This explains so much to me as to how the U.S. patent passed, because these guys, they really were on the clock. They don't have time. They have 12 million patents. So it's like this is the results of, I wouldn't say the results of laziness, but the results of them using a system that's the most efficient to get the work done. So as a result of that,
and then if they get it done and they grant the patent, it's not their problem. They're not going to get sued over the patent.
No, they're not. Yeah, such carelessness can lead to detrimental results for the rest of the industry, for everybody else who's trying to make their own unique type of game, unaware that this is locked in the United States. Like, what does this mean for developers in the United States exactly? Like, if someone wants to make, say, a Pokemon-like monster taming game with very similar systems, are they going to be able to do that in the United States now or not?
Well, a U.S. patent is a patent that is valid in the U.S. market. So it doesn't matter where you're based if you sell in the U.S. and you potentially infringe the patent.
Okay.
That means they could sue another Japanese or Chinese or European company over this as well, if they sell in the U.S.
Really?
That's what the purpose of a U.S. patent is. The same as a Japanese patent is a patent in the Japanese market. A month or two ago, that Nintendo modified one of its patents in the Japanese Palworld dispute. They modified it halfway into the litigation. In
Yes.
mid-litigation.
I remember I reported on that. Yeah, I remember that.
And that new one is terrible in different ways, because that one is essentially about boarding a gliding type of character. And in that one, they dropped what the original patent they had was about the smooth switching. And from that one, they dropped this whole concept of switching, for example, from a horse-like object to a bird-like one. And
Yes.
and that means it's also very broad and very general, very generic. And the Japanese patent office allowed it. And now, of course, the court's going to have to decide. They have a very experienced Japanese patent judge presiding over the case. And it's going to be harder for Nintendo, I'm sure, to persuade him than it is to persuade the patent office. So those patent offices, they do a lot of these things, not only in the US. I really just thought that this was a way of looking at it, because the average person, when people read this, when they see the articles, and I'm very grateful to all these games websites that picked up my story. The first one, I think, with this story and some others was Windows Central Gaming. And Jan, the reporter, very grateful, but I'm also grateful to some others. So there are, I'm sorry if I cannot even name them all, but if any, I'm really grateful. So whether it's Game Rant, whether it's Games Radar, there are various publications that pick up this stuff for me. And in my opinion, that's really in the interest of everyone. It's good for everyone's audience, because I'm not doing a general games website. I'm never going to do that. I'm just focused on some very specific issues where I think that my expertise puts me in a particularly privileged position to figure out what's going on and to then explain it to people.
Well, you're doing great work here, because you're bringing like what is essentially pretty complex topics to the mainstream audience, and you're getting them more informed and interested in this. Because someone like me, who had no clue about how a lot of this patenting stuff works, my eyes have been open today, seeing how the process goes. And I mean, everything here that you know about this, you've been able to summarize for someone like me who's like, duh, right? And now I'm like, oh, I'm a little more enlightened on this. And I like to present this to the gaming community, because the gaming community should be aware of what companies are trying to do, what they're trying to, make exclusively theirs, and how this could affect all of us, because it has already affected our games. Like, I'm a big player in Palworld. I really like Palworld, and the changes that had to be made in that game due to litigation and things like this, it was a real eye opener. It made me want to get more invested and interested in this, and that's why I brought you on. And I really think that you're helping. You're doing a good thing here, because nobody would be interested in this, but because it involves like Nintendo, and it involves a pretty delicate matter for gamers, it's become a lot more popular, a lot more accepted to really talk about this without putting people to sleep, if you know what I mean, because most people have no interest in this. But once it starts affecting their games, once they start seeing changes and updates made, and they're questioning why that happens, you can trace it back to things like this. And now, like, hopefully gamers are a lot more vocal and outspoken towards these sorts of things. I know I've become a lot more outspoken, and now I want to know more and more.
So the games industry, it's a $200 billion business. It's big, and there's money to be made. Some will always try to gain an advantage from lawfare, from using the law as a means of waging war, of staking their claims, of blocking competitors from doing something.
Mm-hmm.
But then, now we get to the more specific part. You said, do they want to be very specific? Well, now here it's not super long, but they say performing control of moving a player character on a field in a virtual space based on a movement operation input. Okay. Mm-hmm. Even if we now say virtual space means it must be a 3D type of environment, it could be that that's what they would argue, that the description here, that it's very much about the 3D type of game. Well, even that, had even like on the Commodore 64, there were games where you were basically running through a labyrinth type of thing.
Yeah,
I think one of them,
there was a game on the Atari called Labyrinth.
exactly. So arguably there was also a field and a virtual space, and you gave some movement operation input, meaning you moved the joystick to the left or the right. That is a movement operation input. So this is still meaningless. Okay. Now, performing control of causing a sub character. That is exactly the type of term, sub character, that if there was litigation over it, there would then also be some argument over that. Because what they mean by sub character here, clearly, of course, is it's not the player character. So you have the player character, that's where they say you control of moving a player character. And then they say causing a sub character, it's obvious that these must be two different things. But what is a character and what is an object? So for example, does it have to have eyes and a nose so that it's a character? Or what do they really mean? One would have to then argue over this. But what we know they mean is you have a Pokemon that you call. That is your okay? Yeah. Or a Pokemon-like thing, like a Pal in Palworld or whatever. That's what they mean. So, lawyers could write long documents, could spend many hours in court arguing over what a sub-character is or is not.
And
so that's where we're talking about summoning. That's where you summon the character. You do something performing control that causes it to appear based on the first operation input. So operation input just means you do something with if it's a video game console, you do it with a controller. If it's a PC, it might also be with a keyboard. Okay? So they say a first operation input. They will later talk about a second one. That's obvious. That's why they say a first. So they talk about two different operation inputs. Now they branch out. Now they talk about, so at this point, they've summoned a character. Here, I must admit, a sub-character and summon, maybe I had some Commodore 64 games where I could do that, but I not right now remember. I'm sure that also existed in the 1980s already in some way, shape, or form, but at the latest in the 90s, of course. When an enemy character is placed at a location where the sub-character is caused to appear. This is a clear reference to the previous thing, so you have the position to which you summon a sub-character. And if an enemy character is placed, and what they mean here by is placed is, in my interpretation, is an understanding, is not that it is being placed, but that it's already there. So it is actually present there. So that is what you get if you, for example, throw a sphere in your virtual space at an enemy character, and to then let this new character that you summon, your fighting character, like your fighting pal or whatever, would pop up there. So it's like throwing your fighting character at the enemy.
Yes. That's interesting because I look at a game like, you don't summon Pikmin, they follow you around, but you do throw them in a 3D space at an enemy. There's lots of other games that also follow this basic concept of summoning and using your summon to take out an enemy. Like Diablo, for instance, has you can summon, or even something like Final Fantasy, right? So there's various games that do this already. And it's even down to the very specifications that's listed right here.
Yes, well, exactly. So we need to look at this. We need to look at it first, bottom up. We look at each of these elements, but then we also have to look at it top down and have to say, is the totality of that something that games have already done before, that games are currently doing? Right now, we are doing the bottom up thing. We're looking at each of these elements. So we're developing an understanding of what it means. Then it says, and when the anime character is not placed at the location where the sub-character is caused to appear. And by the way, this does not necessarily mean throwing a ball. You could also summon it there by just point at this and you put it there. So
Right.
at least the claim language does not require throwing a sphere, but that would be one potential implementation.
See, that's why I think that it's very specific here in order to seek more legal action against Palworld, because in Palworld you do aim in the direction in which you're going to summon your pal. Now, when it comes to that, there are some games where you do throw your summon in a specific direction, where you aim it in a direction, but it seems very specific to me to Pokemon and Palworld in this case right here, because so the newer Pokemon games do allow you to throw your Pokemon in a specific direction, which wasn't the case before.
Yeah, but these claims are the same ones they filed already in March 2023, and they had no idea that Palworld was going to become such an incredible success. Palworld had not been launched. They did not know what the ultimate Palworld game would look like. Well, there had been some demos. I think they already demoed something. They previewed something already in 2021. So they knew that was coming up. They probably weren't too afraid of it. Palworld does this summoning. They changed that. You talked before about how they changed game mechanics. So now you summon them and they are right next to your player character. But I'm just trying to explain what this patent does, not what Palworld does, right? But
Right, yeah.
As an example of like what could it cover, what would it not cover? So when they say when the enemy character is not placed, that is something to also then look at when interpreting a patent, whether there are two things which are mutually exclusive. Either the enemy character is or your sub-character pops up, or it's not there. Those are the two possibilities. And then they say if so, we've already discussed what do they do. That in that case, in the first mode, there would just be the battle would just proceed based on an operation input. So you could, for example, like click on a button that says fight or an icon that means fight.
Mm-hmm.
Then it says when the enemy character is not placed at this location. So that means your sub-character, your fighting Pokemon is summoned, but the enemy character is still a few steps at least away.
Mm-hmm.
By the way, this is also something over which lawyers could potentially fight in court. What really does it mean at the location in technical terms? Because the narrowest understanding would be that it would be the exact same coordinate in the virtual space. The same XYZ coordinate that would have to be precisely there. Now, how close or how far away is still where the sub-character, etc., is, and what is too far away? They're not saying within a range of 100 pixels or something.
No,
So
yeah.
that is something where you can then also argue that you can have endless debates over that. But now imagine if you were one of the pocket pair decision makers, and you have access to great lawyers based on the quality of the defenses. That's just what I could say. And the reputation they enjoy in the patent law community. They will explain it to you, and they will also tell you what options you have to win.
Okay.
I think they are probably going to win. I think that the Japanese Nintendo versus Palworld, Nintendo versus Pocket Pair lawsuit is probably not going to end in a meaningful win for Nintendo. It could be a meaningless win, the kind of thing where you get $5,000, but nothing changes.
Yeah.
But they are certainly being very conservative, very cautious. I have this feeling that it's probably it's not that they don't know it, but it's the problem that they're very uneasy, presumably, with just the situation of facing something that they never expected, probably, and that they're not familiar with. For me, having been in courtrooms hundreds of times, hearing these types of arguments, looking at these things before, looking at them later, seeing the decision, if I were in their shoes, I would not take that lawsuit seriously. But I would also have to say, well, there is at least some risk of disruption, because what if I'm wrong? What if I'm too optimistic and the judge actually says, one of these three patents you do infringe, could that cause disruption? That's what I understood from their public announcement, where Pocket Pair said, we are doing these changes now because we think it's essentially the lesser evil than having maybe more disruption later. So that is one angle from which to look at it. But again, if I personally, do I think that those are serious patents? And I don't think so. But then they're getting sued in Japan. Nintendo is huge in Japan, has litigated in Japan before. Pocket Pair has not. This is the first time they have to deal with patent litigation. There are three patents in play. It's they're just being very cautious. But I would not interpret that as them actually having given up. It's more like this, they would like, I think, to create a situation where maybe Nintendo would just say it's not worth it, because even if we sue and we spend all of this money and time, they're just going to change the game. So what is it good for in the end? Does it benefit Nintendo? It won't. But when all is said and done, I think some of the stuff is going to come back. Mm-hmm. So at some point, they just bring back the feature. And I think we will see that. That's my prediction. We will see Pocket Pair at some point saying, we're now bringing back some of these gameplay mechanics because we have now defeated these patents. That's my prediction.
You know what? You're probably right. You're probably right on that. And what we have right now, because it's not like what the changes they made were significant enough to ruin the entire Palworld experience. They're the smallest of subtle changes that in time we might see some of that make a return. And I think they're being a lot more cautious than I would, for sure. So, because I mean, I'm looking at it from
me. I would be less cautious as well. I'm quite sure. Yeah. But then every company has its own culture. Every decision maker has a certain mentality. It's just that this is, we will see what comes out of this at the end, because Nintendo could really in the end face a major embarrassment. It could be a total loss, and they would just look like a patent troll in the end.
Yeah. But the worst outcome is that they win, and it sets a terrible precedent for the rest of the industry, and perhaps they start seeking, litigation amongst other developers, other games, and that's the worst outcome I could imagine. But I don't see that outcome happening. But like you said, it is an era where these game companies are seeking the most amount of patents, the most amount of litigation possible. I don't have much more I can say on that, other than the worst outcome I don't think is going to happen.
There could even be some litigation fatigue. That is a phenomenon, that when companies have this going over an extended period of time, that they lose interest in it. We will see what Nintendo is going to do next. Are they going to try to escalate? Are they going to try to sue in the US? Are they going to do more? Or are they just going to let this lawsuit progress in Japan, and we'll see what comes out of it? I would be very disappointed in that really well-known Japanese patent judge Nakashima. I actually saw a picture of him just a few months ago where he was sitting next to one of those European patent judges. So he really is a member of this patent law community that I was talking about before. Mm-hmm. If he really agreed with Nintendo that those patents are valid, that they're using against Pocket Pair, and ordered some kind of injunction or whatever, and then people look at that and it's really ridiculous because it's not what the patent system was made for. The patent system, game rules are actually explicitly excluded from what should be patentable. That's why they have all this language in there, such as non-transitory storage, etc. That's to distract from the fact that it is actually a game rule that they've patented, or a combination of game rules. But that's, if he really if he sided with Nintendo, it would be, again, disappointing, because he has a reputation for very reasonable decisions. Then we'll see what comes out of it. At this point, this patent here was not actually tweaked for the purpose of using it against Pocket Pair, they didn't do any tweaking because the patent office granted it in this form, period.
Yeah.
Now they have it. What will they do with it? We will see. If something happens, then maybe we'll reconnect and then talk about a specific lawsuit. But at least we have all helped generate some awareness, because I think the games industry and the gamer community, they should know about what's going on here. If Nintendo really won against someone, doesn't even necessarily have to be Pocket Pair, could be the next one they go after. So good luck with doing all this editing, and thank you so much again for having me.
You've been amazing, Florian. I am looking forward to talking to you again very soon.
Free Congo sucks ass.